because in some cases English isn't a first language, and I don't assume that everybody necessarily will be able to follow it in the same way, but if there are people who are able to translate it and you want to translate it as I go along to your neighbour or someone behind, feel free to do so. I will not be distracted if that is the case. It begins with a citation from the founder, essentially, whose vision this was in the first place, Bertrand Russell, who said this in November 1966. "May this tribunal prevent the crime of silence." The Russel Tribunal on Palestine is an international, citizen-based tribunal of conscience, created in response to the demands of civil society, NGOs, charities, unions, faith-based organizations, to inform and mobilize public opinion and put pressure on decision makers. In view of the failure to implement the advisory opinion of the 9th of July 2004, and as I said yesterday, I carry it everywhere, I have it here, from the International Court of Justice, otherwise known as the World Court, concerning the construction by Israel of a wall in the occupied Palestinian territory, the failure to implement resolution ES 1015, confirming the ICJ, International Court of Justice, opinion, adopted by the United Nations General Assembly on the 20th of July 2004, and the events of December in Gaza 2008, January 2009, committees were established in different countries to promote and sustain a citizens' initiative in support of the rights of the Palestinian people. Rather than repeat the Russel Tribunal on Palestine, I'm just going to say the tribunal each time. The tribunal is imbued with the same spirit and espouses the same rigorous rules as those inherited from the Tribunal on Vietnam, 1966 to 1967, which was established by the eminent scholar and philosopher Bertrand Russell, and the second Russel Tribunal on Latin America, 1974 to 1976, organized by Lelo Basso International Foundation for the Rights and Liberation of Peoples. The tribunal has no legal status. It operates as a court of the people. The Israeli government was invited to present its case before the tribunal, but chose not to exercise this right and provided no answer to correspondence from the tribunal. Following the hearings and deliberations of the jury, the findings of the third session of the Russel Tribunal on Palestine, held in Cape Town on the 5th to the 6th of November 2011, are summarized as follows. There are several headings. The first one is this: apartheid. The tribunal finds that Israel subjects the Palestinian people to an institutionalized regime of domination amounting to apartheid as defined under international law. This discriminatory regime manifests in varying intensity and forms against different categories of Palestinians depending on their location. The Palestinians living under colonial military rule in the occupied Palestinian territory are subject to a particularly aggravated form of apartheid. Palestinian citizens of Israel, while entitled to vote, are not part of the Jewish nation, as defined by Israeli law, and are therefore excluded from the benefits of Jewish nationality and subject to systematic discrimination across the broad spectrum of recognized human rights. Irrespective of such differences, the tribunal concludes that Israel's rule over the Palestinian people, wherever they reside, collectively amounts to a single, integrated regime of apartheid. The State of Israel is legally obliged to respect the prohibition against apartheid contained in international law. In addition to being considered a crime against humanity, the practice of apartheid is universally prohibited. The tribunal has considered Israel's rule over the Palestinian people under its jurisdiction in the light of the legal definition of apartheid. Apartheid is prohibited by international law because of the experience of apartheid in southern Africa, which had its own unique attributes. The legal definition of apartheid, however, applies to a situation anywhere, any situation anywhere in the world where the following three core elements exist. Firstly, that two distinct racial groups can be identified. Secondly, that inhuman acts are committed against the subordinate group. And thirdly, that such acts are committed systematically in the context of an institutionalized regime of domination by one group over the other. Now we turn to some of the terms in that definition. Racial groups. The existence of racial groups is fundamental to the question of apartheid. On the basis of expert evidence heard by the tribunal, the jury concludes that international law gives a broad meaning to the term racial, as including elements of ethnic and national origin, and therefore that the definition of racial group is a sociological rather than biological question. Perceptions, including self-perceptions and external perceptions, of Israeli Jewish identity and Palestinian identity illustrate that Israeli Jews and Palestinian Arabs can readily be defined as distinct racial groups for the purposes of international law. From the evidence received, it was clear to the jury that two distinct, identifiable groups exist in a very practical sense, and that the legal definition of racial group applies to all circumstances in which the Israeli authorities have jurisdiction over Palestinians. A second term that is used. Inhuman acts of apartheid. Individual inhuman acts committed in the context of such a system are defined by international law as crimes of apartheid. The jury heard abundant evidence of practices that constitute inhuman acts perpetrated against the Palestinian people by the Israeli authorities. These include, this is not an exhaustive list, widespread deprivation of Palestinian life through military operations and incursions, a formal policy of targeted killings, and the use of lethal force against demonstrations. A second example, torture and ill treatment of Palestinians in the context of widespread deprivation of liberty through policies of arbitrary arrest and administrative detention without charge. The jury finds that such measures frequently go beyond what is reasonably justified by security concerns and amount to a form of domination over the Palestinians as a group. A third example. Systematic human rights violations that preclude Palestinian development and prevent the Palestinians as a group from participating in political, economic, social and cultural life. Palestinian refugees who remain displaced are also victims of apartheid by virtue of the ongoing denial of their right to return to their homes, as well as by laws that remove their property and citizenship rights. I'm going to pause for a moment, this isn't in the text, but the laws that relate to this kind of activity we have added at the back of this document. I'm not going to read them out, and there will be an explanatory note available, but that's an example of one of the ones that you'll find in the list at the back when you get the document. In other words, a denial of right to return to their homes and removal of property.